You're like, all right, good afternoon. It is May 27th in Senate Judiciary. We are taking up S-193, which is about to have third reading in the House.
No, it's gone all the way through.
Gone all the way through. And so that will be on our calendar, I believe, tomorrow. And there is a lot to it. There are a number of changes made in the House. We want to just refresh our memory on what those changes were, the general overview, and if we have any questions. We also have Representative Malone here with us, Chair of House Judiciary. But Eric, if you want to provide us just the general overview, and we'll spend time independently trying to figure out details on our own.
Sure.
And so if there are questions, we'll come back. So
yeah. Okay. All right. Good afternoon, everybody. Eric Fitzpatrick with the Office of Legislative Counsel here to give the committee a big picture overview and any details that you want to hear about with respect to S-193 and it's the forensic facility bill, which remember passed the Senate a while back prior to crossover, has now come over from the House last night. And the reason that you've got multiple documents in front of you is because the proposed committee amendment from the House Judiciary Committee passed on the floor last night, as did two fairly substantial amendments to the committee amendment. One that I think you have in front of you that's from Representative Wood as the lead sponsor of that one. That's version 4.1. And then another one with Representative Burdett as the lead sponsor that has the draft number 5.1 on top of it. All of those documents, in addition to the one you don't have, which is the underlying House Judiciary Committee amendment, which I believe Emery's going to have to get copies of, all passed. So they're all going to have to be integrated into one document, which has not been done yet. Because that's a big time, and my understanding of that's still with the House Clerk. So it has not been more read. But as you'll see from the House Judiciary Committee amendment, which Emery is passing out, that one is a 29 pager. The Representative Burdett amendment is a 26 pager, and then you've got another 4 pages from Representative Wood. So all in all, you're looking at a 60-page bill. So it's got a lot to it. I'm not going to line by line it, in other words, and I don't think you have the time or the interest in that anyway. But from the big picture, and particularly helps explain why there's so much volume to the amendment when it's going to be integrated, is that when the 193 passed the Senate and it created the forensic facility, remember, for 2 different populations, people found not competent to stand trial or people found not guilty by reason of insanity. And they were placed in the forensic facility, and generally speaking, their competency restoration services for the incompetent group, other services for the NGRI group, were overseen by the Department of Corrections. That was the body that was overseeing it when it left the Senate. When it went to the House, that was amended in the House Judiciary Committee so that the role of the Department of Corrections, and I should add, I'm sorry, the House Corrections Institutions Committee as well. The bill was, as it was down here, the bill was looked at by multiple committees upstairs as well. So I spent a lot of time in each of those committees. The initial conclusion was to, rather than have all those services at the facility supervised by DOC, they would be supervised by the Agency of Human Services medical director in consultation with the various departments, Department of Mental Health, Department of Disabilities, Aging, Independent Living, Department of Health, because the folks that are there as a result of some mental health condition, and which department is providing services to that person. That depends on what their condition is. For example, a mental health condition is DMH, intellectual disability, scale, that sort of thing. So that was the initial proposal. The amendment from Representative Burdett and others, actually, if you looked at the list, it's actually Representative Burdett and pretty much, I think, 10 of the 11 members or so, 9 or 10 of the 11 members of the House Judiciary Committee also co-sponsored that amendment. So that, and in consultation with House Corrections Institutions and other substantive committees upstairs, come up with a different plan. And the plan is this. So the Department of Corrections would be involved as the lead body. both in terms of supervising a person who's released, providing security at the facility, that sort of thing, and the sort of lead entity, but only temporarily. So that's one of the reasons you're looking at two voluminous amendments that are coming together here, because the way it's structured is that for the first 3 years, the Representative Burdett amendment couldn't have timed that any better. The sponsor is here. That is the amendment that puts DOC back in as the lead person in consultation with these other departments, Dale, GameAid, et cetera. But that lasts for 3 years. And the idea there is that it's going to take time for a forensic facility to be up and running. It's not going to happen right. And there needs to be time to plan, to think about where it's going to be. Should it be a new facility? Should it be co-located with an existing facility, et cetera? So since that's not going to happen right away, but there are still people who would otherwise qualify for the forensic facility if one existed. So they're going to need those services. That person would still be in the DOC facility now, were it not for this option of a forensic or competency restoration program. So that's the proposal. You're going to have two different effective dates, and one effective date, which will be July 1st of next year, as it turns out, will be for this competency restoration and forensic program run through the Agency of Human Services with DOC as a lead body, and that will be in effect for 3 years. And for that 3-year period of time, the Agency of Human Services is going to be working on a feasibility plan. They got to come back with a feasibility plan to propose where such a permanent facility could be located, how it would be staffed, how much it would cost, that sort of thing. But the idea is that other section actually in this case, it's the underlying Judiciary Committee amendment that has DOC not involved as much, right? That mainly the departments within the Agency of Human Services. In council, they consult the agency, but for the most part, DOC's role is very limited to providing security at the admitting area, around the outside perimeter, if it's co-located with on a forensic facility, et cetera. That part of the bill, those sections, don't come into effect until July 1st, 2029. So during that 3-year interim, which is what Representative Burdett et al.'s amendment, during that 3-year interim, you have DOC being the lead body on a forensic and competency restoration program. We're going to run through DOC. It's in effect temporarily as a sunset. And also, as part of the amendment, the agency is required to establish emergency rules to lay out how that interim temporary competency restoration program is going to be operated.
So can I just want to see if I'm understanding the flow chart here.
Yes.
In the bill's current form, with all the amendments considered attached to it,
right?
Is the process now that for the next 3 years, DOC is taking the lead on this for the individuals who are already in DOC custody, and then at the end of the 3 years, there's the expectation that there may be a separate facility or a co-located facility, at which point DOC would essentially hand over the reins to DMH, was it?
Well, actually, AHS, and all the departments within AHS who would be supervising the population.
And there will be emergency rulemaking. Were you about to go over the emergency rulemaking?
No, but I could. You're right. The only thing I would add to that is that during the interim 3 years, it would not only be people who are currently in DOC custody. There could be someone during that 3-year period who might be, remember the criteria, someone charged with an offense with a lifetime maximum, held without bail, found incompetent to stand trial or not fit by reason of insanity, et cetera. Someone could meet those criteria in the meantime.
Right.
And the emergency rules have to establish this program consistent with the statutory language that goes into effect now in the meantime, so that it would cover people who might be who would otherwise qualify for the forensic facility prior to July 1st, 2029. They could be and would be qualified to be there as well.
Thank you.
Yeah, I just wanted to real quickly, even these 3 the interim period, which we were also kind of talking as a bridge to get us to the permanent facility. AHS medical director is in charge of the clinical side of this. DOC would not be doing the treatment. They would be providing the security within the facility because it's in a DOC facility. The biggest difference after that with the permanent facility is that DOC would not be in the facility providing that security because presumably we'll have a separate facility. They would still be able to provide security outside. The other big difference is after this bridge period, DOC will have less involvement in the monitoring of any individual who happens to have been released pursuant to the order, or pursuant to supervision, which has not really changed that much from what we got from the Senate, that component of it.
After the 3 years,
After the 3 years, DOC would have less involvement in the supervision.
how would that work if they're putting somebody on probation or parole or anything like that? Am I missing something?
If they're incompetent to stand trial, they don't have a sentence because they haven't gone to trial.
It's not probation.
It's not
different.
probation,
It's
parole.
supervision by the departments under AHS, including DOC.
Right. And there'd be a
Oh.
risk assessment
it's
done by a department of Dale or mental health.
Right. There's a risk assessment that is done to.
So these are the situations in which it's determined that their qualifying condition wouldn't create a substantial risk of injury to another person. We're talking about those people who are getting released
Right.
and kept under scope. I get it.
But also it could be that they're not restorable. It'd be not restorable and not dangerous, or a lower level of danger where they could not be in the forensic facility.
Okay.
So if they did regain competency and they went to trial, they'd be sentenced. And then they could be on probation, which PMP would be monitoring them with conditions from the court, or furlough. PMP would monitor them in the field with conditions from DOC, or parole. The PMP officers would be monitoring in the community with conditions set by the parole board, but they've been sentenced. These are folks who
Right. They're not sentenced.
they're not sentenced.
So it's a different kind of
It's
supervision.
a different kind of supervision. And we also included language that would help our PMP offices based on staff and resources available to them, because it's a different population than what they're used to in monitoring out in the community. So they would need different training and tools.
Got it. Thank you. Senator Mattis, I know you have a conference committee to go to. So I did text Senator Baruth to see if he can join us so that we can at least have a quorum. I believe we can still continue listening, but we can't make any policy decisions with only 2 members. So
So I do have and maybe you're going to get to it. I'm glad that Chair Lalonde mentioned that DOC is under the umbrella of AHS.
Right.
However, in having 13 minutes to read these documents here, I haven't gotten that far yet. But what about at the end of 3 years? In fact, we don't have this facility. So also, what is plain B, or is that in the work as far as DOC involved?
I think you could almost sort of look at it as it might be reminiscent of a raise the age situation. Remember, sometimes when you come to the end of the period when the next age group was supposed to come under the family division as juvenile court, and the committee had the legislature on several different occasions have looked at it and said, well, it looks like they're not ready, so you extend the date. You got 3
So
years.
the legislative action taken, in fact, at the end of 3 years, we didn't have.
Yeah, or if you're at 2 years and you see at that point, well, it looks like you're not going to make 3 years, you can always extend it for another year. And in fact, there's a lot of sort of check-ins, legislative check-ins that are envisioned in the bill as well. So I didn't mention this, but for example, the emergency rules are supposed to be in effect by the end of this year, December 31st of 2026. But that's when they have to be adopted. They don't actually go into effect until July 1st, 2027. So that gives the next legislative session for the legislature to look at those emergency rules as they were proposed, provide any feedback with the agency, or make any statutory changes that you think are necessary before they become effective. And then, in addition to that, at Joint Justice Oversight this year, both the August and the November meetings, the bill requires the Agency of Human Services to report to JJOC about both the emergency rules and how they're going, and then what's known as in the bill as a feasibility plan. So the agency also had to come up with a feasibility plan that talks about location, design, planning, costs, et cetera, related to the permanent facility. And that's, I think, also due mid-January 2027. And the agency has to report on that to Joint Justice Oversight during these 2 meetings in August and November as well. So there's opportunities, in other words, for the legislature to see from the agency how you think it's going, provide feedback, make any statutory changes next year that you think might be necessary. But in response to your question, Senator Norris, yeah, that's the idea, is that if it looks like the date isn't going to be met, then you have an opportunity to extend it. So I can talk about a couple of other substantive differences. Think that would be helpful.
Yeah, that's our,
big
I'm trying to get
picture.
a sense of, I mean, I've got a sense of what the timelines and the flow chart looks like, with these changes with the 3 years and so on in the emergency rulemaking. Any other substantive changes that are drastically different than compared to what we passed out?
There's a few that are additions and changes, not a huge amount. I think I would say much of the court process in terms of, for example, keeps the standard that the state's attorney has to prove that came out of this committee, clear and convincing evidence that the person has a qualifying condition and would be a danger to another person. The same essentially as it came out of this committee, but that does have one difference, which is that you may or may not recall that there's as the bill came out of this committee, and as it I think came out of the House Judiciary as well, this one was a modification from the House Human Services Committee, that the causality connection between a qualifying condition and that someone is a substantial risk of bodily injury to another person. So in other words, the state's attorney has to prove someone has to be involuntarily committed to facilities, that they've got a qualifying condition, and that as a result of the qualifying condition, they're a substantial risk of bodily injury to another person. So it's the qualifying condition that causes this substantial risk of danger, is the shorthand way to put it. The final version of the bill is that both have to be present. The person has to have a qualifying condition, and they have to, state attorney has to prove by clear and convincing evidence that their release would cause a substantial risk of danger to another person, but doesn't require the causal connection between the two things. They both have to be shown they have the condition and they're dangerous, but not that they're dangerous as a result of the qualifying condition. I think that's a substantive distinction, but one that there's precedent for in the current Vermont statutes. For example, the Dale Commitment for Intellectual Disability purposes in the Vermont statutes currently it also requires intellectual disability and danger. Doesn't have to be that the intellectual disability causes danger.
That severing of the causality,
Yes.
where did that come from, and what was the impetus for it? And if any of the reps said any.
It was from Human Services. And their reasoning, from what I understand it, is that the way the language was suggests that because you have a mental illness or because you have this cognitive disability, you are dangerous.
Mm-hmm.
And they wanted, philosophically, as much as anything, to separate those. So you may have this cognitive disability. That's not necessarily why you're dangerous.
So
Yeah, no, go ahead. Yeah.
They were afraid somebody like with Alzheimer's or the traumatic brain injury that didn't really qualify for forensics were going to get caught up.
got it. Okay. That makes sense. And Eric, can you remind me where that is in this amendment?
Throughout.
Okay.
Yeah, many times.
Okay.
That language, that standard appears many times, so it has to be changed in each instance. Another addition that was made, that was not in the Senate proposal, or the Senate passed version of the bill, involved commitment to the Department of Disabilities, Aging and Independent Living to Dale. You may recall that when there's a finding by the court that a person is non-restorable incompetency, the court might release the person if the court is non-restorable and not dangerous, that's to make a finding regarding dangerousness, they'd be released under conditions, under supervisory conditions. Or if the person was non-restorable and dangerous, the court could order continued commitment of the person. Proposals that there's a third option. If the person's qualifying condition is an intellectual disability, then instead of either replacing the person at the forensic facility or releasing them, it could be, if they were dangerous as a result of this intellectual disability, they could be committed to jail. And that tracks and parallels the existing what's called Act 248 procedure. If someone with an intellectual disability can be committed to jail now, if they have committed a crime and have found to be incompetent on the basis of the intellectual disability. So it provides the court with a third option once someone is found to be non-restorable. So that's a substantive and fairly lengthy substantive addition because there's a lot of process as to how, and again, it tracks that existing Act 248 process, but it's also reprinted in the bill.
Apologies for being a minute or two late, and you may have already covered this, but were there changes to the effective dates or repeals?
Yes.
Because if I'm looking at the right one, it looks as though they're over. So you'll get to those.
I did, but I can hold some up for you. I can sum up for you. Yep, absolutely. Yeah. The idea is that you've got two different systems proposed here for treating people who would be eligible for the forensic facility. One of them is similar to the version that came out of the Senate, in that the lead state agency for supervising the person who is at the facility is the Department of Corrections in conjunction with other departments within the Agency of Human Services. In the other version, which was in the I'm not sure which one you're looking at there, the 5.1?
5.1.
Okay, so that's the Representative Burgess amendment that passed on the floor last night. That actually that tracks with what passed the Senate. That's the one where DOC has that lead role. Now they're not the lead role as Chair Lalonde was indicating earlier. They're not the lead person for providing clinical service. That party is still the Agency of Human Services medical director in combination with the departments. But they do have a lead role in terms of security, supervising the person when they're released, that kind of thing. However, that has a temporary effective date. It's a 3-year. That's why you see sunsets and repeals. That provision has a sunset in 3 years, July 1st, 2029. At that time, the version of the organization and structure of the forensic facility as passed the House Judiciary Committee, because what you're looking at was amended on the floor, an amendment that passed on the floor. The version that passed out of House Judiciary, which in that case, the DOC is not the lead role anymore. It's the Agency of Human Services medical director in consultation with the Agency of Human Services departments that would have supervisory authority over the person, depending on what their qualifying mental health condition was. DOC still has a limited role to play, but it is in the language, for example, if you look at version 7.1 in front of you there, just to see an example of how DOC's role. Somebody have a 7.1 there?
Yeah.
Look at lines 13 through 17.
On the first page?
Yes. That provides you an example of the general principle of limiting DOC's.
Well,
And that version becomes effective July 1st, 2029. So that's the reason that you're seeing the effective dates, repeals, that sort of thing at the end. It lays out a bunch of sections, says these sections are effective now until July 1st, 2029, and it lays out a bunch of other sections and said these are effective at that time in 3 years.
okay, so there's 3 regimes, for lack of a better term. There's the emergency rules. Those get repealed. And then sections 9 and 11 get repealed that same year.
But those are, I would view that as part of one regime. The emergency rules have more the details that are inconsistent with sections 9 to 11 that are in effect.
So those are bridging sections in effect.
Exactly.
Okay.
In fact, so the bridge is pretty similar, except for the DOC involvement. The process, who gets put in there, the processes for who's there, the exits that they can make if they're not repairable. that they can't be restored to competency. Those are really quite similar. So sections 2, 4, and 5, which would go into effect in 29, are quite similar to sections 9, 10, and 11. It's just some adjustments so that we recognize that this is going to occur inside a DOC prison in the interim. And the big push on that was we don't want folks languishing while we're waiting for this facility that will have less DOC involvement.
Yeah. Thank you.
So actually, Eric, are there any other substantive changes?
The couple other notes I made, there, the House adds a provision that, there's a lot of evaluations that are involved here. Remember, think about it. So, like every 6 months, someone can get their competency reevaluated. For example, you can ask for it to be an evaluation of restorability. House added some language that anytime there's an evaluation required, the defense can conduct their own evaluation, so they can get an independent evaluation if they want one. There's some provisions added about victim notification, so that when these hearings have to occur on a regular basis, victims have to be notified. Has to be a reasonable effort to notify victims, and they have to be offered an opportunity to be heard if they can be located. And the only other thing I noted was the initial hearing in the NGRI context. That's not guilty by reason of insanity, and that's the version that has. You remember, so if someone gets found not guilty by reason of insanity of one of those qualifying offenses, and they meet the other criteria, they are placed in the forensic facility. And as the version that passed the Senate required an initial hearing in 72 hours, and the House wanted 60 days of that. So the initial hearing is a little bit longer. That's a long time. Senator Ruth.
Just a quick question for the chair. I'm looking at the list. Is this the list of all the members of Judiciary brought this?
No, Barbara Rachelson, I don't think was there she was out for like 2-3 days. I don't know if she would have signed on, but she was
Substantially from the committee.
Yes.
This 10 of the 11.
Yeah.
Okay.
Yeah.
Great. Just wanted to make sure it wasn't random.
No, it was one that we worked on quite
Every other.
Would anybody be able to explain the going from the 72 hours to the 60 days? And
you could probably get the best explanation from Tim McManus or Jared Bianchi. I think part of the issue was that, again, looking at the population, that this is somebody who has essentially agreed that they did the crime, and it's a life offense, but they are not guilty by reason of insanity. So it's a little bit different concern as far as having 60 days, because this person is not likely going anywhere soon. Even under the current regime, it would be some, there's not even a clear path for that individual. So I think, we were less concerned. It didn't raise huge concern. We didn't hear any pushback on that I recall. Well, no, I take that back. I think Matt Valerio may have very well said 60 days was too long. Or he didn't say 60 days was too long. He said that could be done in shorter time. He said we didn't need 60 days.
okay. All right.
And the one, so the one suggestion, I know when I look at this, when it's all together, I'm going to find some things because it's pretty extensive bill, and we've been working on it for several weeks, and honestly, I've already spotted one thing. It's not a big deal, but it's one that I'm planning on going back to when I sit with this, when I see the rules that are going to be done by the end of this year. This is going to be coming back to adjust things. So if there are any things, hopefully there's nothing fatal in here, because I am concerned that, if it's turned around and sent back to us, is it going to time out? There's always my concern at this time of year. And that we have set up, and that's purposely why we extended the effective date of the rules to July of 29. So we'd have a chance to go look at the rules and look at the statute again, kind of in conjunction with what they've come up with. And maybe if you're worried about the 60 days, it'll be time to address that.
I wouldn't say I'm worried about the 60 days. Just recalling in my memory, thinking that 72 hours probably was going to be changed now that I'm thinking about it. So,
Right.
I get it. Yeah, I was just curious about that. Representative.
Representative Evans, Chair of House Corrections and Institutions, and to follow up a little bit on that in terms of once this gets in place and is signed off, Joint Justice Oversight Chair of that can really make a commitment that we can look at this off session. There is some reporting back anyway for the feasibility plan, but I think, there's 4 of us here right now who are on that committee, and I think we're so focused in that we can spend some time in our meetings off session to really follow up on this piece of legislation and make any recommendations for next term.
Good point. Thank you. Eric, any other changes?
I think that was what I wanted to cover. So I think
I just wanted to open up for the reps who are here. Is there any other points that we should be aware of that you want to share with us?
I don't think so. No, I think the main thing is the way I've been looking at it is that we've got the court process that actually Judiciary really focused on. The Judiciary Committee upstairs as far as who's going to go in and what are the processes for them to go in and to get out essentially. And then the second component was what is this forensic facility need to look like, both in the interim, and that's section 5 and section 11. What's going to look like in the interim and what's going to look like in the long term. That's still mostly Ginny Lyons language. There's some fairly minor adjustments to that. But yeah, that's mostly Ginny Lyons language. And then there's where is this going to be and who's going to ultimately be running it. And that's where there's the feasibility plan, which is new from what we put in here. That's supposed to also come to us by the end, well, by January 15th, I believe is the date. So those are kind of the ways that I've kind of thought of it in my mind.
And the feasibility plan came from my committee, corrections and institutions, to really say, hey, let's be serious about this. Let's work it through. Let's really figure out who's going to operate it, who's going to provide the clinical services, who's going to provide the security services, and what the cost is going to be. So,
And where it's going to
And
be.
where.
As well, yeah.
because it could be on a ground of a correctional facility, those separate. And, or it could be cited someplace else. Those sightings are really hard to do. That's what we've tried with the juvenile women's facility. So that's why we had that feasibility plan again come back to Justice Oversight twice to keep their feet to the fire, that we really do need a forensic facility that is operated clinically through the Agency of Human Services. And security, if it's placed on the grounds of a correctional facility, then the security outside the building and at the entrance would be by DOC.
Yeah, and the only thing I would add too is that as Representative Evans was describing the feasibility plan, it reminded me that as we did down here, Katie McClin in our office was the attorney who drafted and worked on some of those other sections. So just wanted to say, I said that I didn't think of anything that I missed, but I wanted to ask if Katie noticed that I missed anything because she worked on those sections with Representative Evans committee and other committees upstairs. So in case I missed something when I was trying to highlight the major differences.
Thank you. No, I think we've covered it. So there's the clinical section that came from Senate Health and Welfare and Corrections, institutions. And that was not changed a whole lot from what happened in the House. So that section's coming back to you intact. There was a change in definition from what was in the Senate version. So now the forensic facility would be licensed as a TCR, therapeutic community residence. That is a license type. It's run by Dale, but that doesn't mean that Dale population is the only population that can be in it. And so other facilities like the your residential recovery facility is also licensed as a TCR. And there's some recognition in the feasibility plan that the TCR rules are a perfect fit for the forensic facility. So there need to be some modifications to the TCR rules to enable the forensic facility be licensed at the TCR. So that's one of the changes.
And that's only goes into effect in 29. We took that language out for the interim because DOC is not going to be a licensed facility.
Committee, any thoughts, questions, comments?
I'm assuming we're gonna take a vote on this, and now I'm in a position of saying, okay, that our house colleagues get this right, correct all of our mistakes that we sent to them, okay? And if I have some reassurance and that's the case, then we probably can move forward in my mind on this, but I'm not gonna speak for the other senators on the committee here.
So I can say this, that, so of the people who we've talked, a lot of testimony on this. And, the state's attorneys, DMH, Dale, AHS, all are satisfied, if not pleased, and some of them are even pleased. But also, Matt Valerio, he came in early and said, we need a forensic facility, agreed with that, but we need it to be constitutional. And here are the issues that I have as far as why this might not be constitutional. And by the end, we had addressed all those issues, because I circled back to him, including with the amendment that, for the interim, and he's fine with where we are. And I thought that meant a lot since, so he was questioning some of the constitutionality issues that the due process of the areas there. So I don't know if I corrected everything, but, we corrected what Matt Valerio.
We'll have the opportunity this summer or whatever.
Yeah.
We'll work on it this summer.
And the court will weigh in too.
Yeah, the court will
Absolutely.
finally know this. Got this right.
So I'm inclined to concur with the House. I don't think I'll be able to report this out today because there's a lot to it. Sounds like it's gonna be 60 something pages. But it's technically not even on our calendar, so I can't report it today. It's right.
Well, we could pull it out pending this, but it's fine to leave it until tomorrow.
Yeah.
Hasn't even come over yet? Curious about that.
It may not.
We messaged
It's a
it
big
last
job.
night, didn't we?
Yeah, but they need to put it all
A lot
together.
of time to integrate all those events.
Yeah, so-
Why not gonna happen?
We're gonna be here tomorrow, right?
Absolutely.
Yeah, okay. So I just want to make sure, I figured I should ask.
Well,
Sure, so I'm,
You guys are always telling people days that, like, people from the house were telling me we were leaving last Friday. Then they were like, we're leaving Monday, and I'm like, we're not even meeting Monday. Now they're saying today.
Who are you talking to in the house? Huh?
We're leaving.
Just general rank and filers. The people that
Not
are,
all freshmen, obviously.
but, even Connor wasn't coming off the Wednesday meeting until this morning. So, I don't know.
We try to have a sense of urgency, so.
We're ready to suspend rules and get out of here.
Yeah.
so we could pull this all supportive of background with this.
That was mine.
I would do.
That's what I told them.
Okay,
We
great.
could do that
So
all day.
I'll meet with you at some point, Eric, just to make sure I got the presentation and the differences ready for a report for tomorrow, and then
Sure.
we'll take it away.
Yeah.
So, thank you.
Yeah, sounds good.
Thanks for your work.
Yeah, no, thank you. Thank you for your
Thank
work
you.
as well.
Thank
Thanks
you.
for
We'll
looking
keep on
over
it
to
this
us and
summer and fall.
giving us a
Yeah.
chance to work on it for a few weeks.
Yeah, it's just one of those.